website. So those who are attending and paid, if there's some reason you want to try and get it into the recording, we'll have to work on that. Again, we're just trying to help everybody here. And I did want to introduce, as we have walked through, again, Emily, after having been so long involved with us, moving on to her new opportunities, that we have engaged with McDonald and Associates, an association management firm in Sacramento. We went through a process of reviewing, selected them, very encouraged, and think they're a really good fit for us. They'll be taking care of the association management part, and I will still be here, obviously, as risk manager. And I was looking for Cheryl on the list. Cheryl Marcel, our new executive director through McDonald, and don't see her, so we'll try and catch up with her in a little bit. And so if you would, as we go through, enter items in the Q&A, that'll be important. We'll try and answer them as we go through for the most part, but you know, we're going to cover a lot of ground in 2 hours, so we may delay some until the end as it goes. So PAGA Reform, very, very big deal. Again, webinar is being recorded. Please go ahead and use the Q&A for us as you have an issue. And again, if you have a technical issue, call Deneen. She'll take care of you. So our presenters today, obviously our members, most of you know me as Director of Risk Management. We have Kyle Kring and Chung. Kyle's been with us from the start. An attorney supporting, encouraging our association and our members. And Kerry Kramer's been part of his team and has helped us a lot with labor law issues as they've gone forward and developed. So what happened? PAGA Reform. Let's just jump in. There were 2 bills. Oh, there's Cheryl. Cheryl, do you want to, why don't we take a minute? Cheryl can introduce herself as our new Executive Director of Housing Contractors of California.
Yes, I was logged in, but I wasn't logged in as a panelist, so you couldn't see me. So I went out and logged back in. But thank you so much for having me at McDonald Association Management Company. We're excited to be a part of the team for HTC going forward. And Deneen and I will be available to answer any questions and help the association go and grow and thrive. So we're excited to be here. And thank you all for joining us, and turn it back over to Bruce for the rest of the webinar. Thank you.
Great. Thanks, Cheryl. Okay, here we are. PAGA Reform. There were 2 bills that wound up with the negotiated compromise issues, AB 2288 and SB 92. One of them, the Assembly bill authored by Ash Kalra, who I think wanted his name that he could, for the next 15 or 20 years, tell, you know, labor and plaintiff attorneys, I authored your bill and you should be very happy with me. And, you know, I'm your hero. All the labor and plaintiff attorney wishes were put into his bill. And then SB 92, the author was Senator Tom Umberg. As chair of Senate Judiciary, was what management primarily wanted out of the agreement. So it's really important to note there was unanimous votes in both houses. And we, you know, as housing contractors of California, we've been pursuing this for many years. Our legislative days for the last 7 years have, PAGA reforms have been a big deal. We have, made it this year, June 11, our legislative day when we were in the Capitol. It was our only issue talking about the need for PAGA reform and so forth. So a lot of grassroots effort helping that the vote be unanimous. That's a big deal. And we know some of the artisan members and California framing contractors members as well, the grassroots effort with your legislators, and we greatly appreciate that because nobody held out. And that's a big deal. And the fact that there was no opposition. And not only nobody wrote in opposing the bills, but most unions wrote in support. The plaintiff attorney associations wrote in support. So if somebody tries to undo this, they're going to say, how can everybody have been on board for this? How could anybody have missed anything? It's a big deal as we go forward that hopefully nobody tries to take this apart, but that kind of legislative history is really valuable. So the bill was effective immediately because it had more than 2/3 of a majority. The governor signed it on July 1 after he got back from defending President Biden in Atlanta after the debate. We were hoping he would sign it like June 20 or something like that, but I'm sorry, on June 28th or 9th, and he was out of town, shall we say. It does cover PAGA filings on or after June 19. That's an important thing. Plaintiffs' attorneys filed about 420 PAGA filings June 19 and 20 before they realized that June 19 was cutoff date. And they were quite surprised and unhappy with that development, but that's their problem. We're not worried about it. So how do we get reform? How do we keep it? As we discussed many attempts over the years, we want to greatly appreciate an employer coalition. 3 main parties: Western Growers Association, a very large agricultural group; the New Car Dealers Association, obviously dealers all over California; and Cal Chamber got together and put a coalition together and raised over time $12 million to put an initiative on the ballot in 2024. And that's a big endeavor to raise that kind of money. Most of the money was raised between those 3 associations, so we appreciate their leadership there. Having that initiative on the ballot qualified in November allowed the coalition to go to the governor, to go to labor and say, we should cut a legislative deal so we don't spend huge amounts of money on a initiative. The initiative would have been great had it passed. It totally eliminated PAGA. We would have obviously greatly preferred that, but it would face a tough uphill climb. And as you know, some of these initiatives run into the $100 and $200 million of money to try and get them over the top. So thankfully, the needs of labor, management, and the governor aligned, because Governor Newsom, whatever's going on with him, his future aspirations, etc., I think he really, really wanted to sit, as he did July 1, at a table with the 2 authors of the bill behind him and labor and management representatives on either side. And he's signing a bill that was a compromise that everybody was reasonably happy with. So we thankfully had all those groups, and because they were aligned, plaintiff attorneys had to come to the table and be a part. I think it's important for us to recognize that the employer coalition, with their large input of money, forced a meeting at the table, but they were still the shortest chair at the table because labor plaintiff attorneys, they are hugely influential in the Democrat supermajorities in both houses of the legislature. The governor is very aligned with labor and plaintiff attorneys. So they had to still negotiate a bit uphill, but at least they're in the room. They worked hard. And as you know, there were really 2 rounds of negotiations. While there's not a lot have been said publicly about all they went through, it's clear 2 things happened. One is they got an agreement in principle that each party, labor, management, plaintiff attorneys, got what they really wanted out of the deal. Obviously, plaintiff attorneys would prefer the status quo, but when they knew things were going to change, they had a couple of serious wants. And then the second round of the negotiations is, okay, our agreement in principle, you got what you wanted, but now we need to hammer out the details so nobody can exploit what they've been given. And you'll see, especially as Kyle and Carrie walk us through the details of the legislation, there's a lot of back and forth and, this phrase inserted to keep this party from doing this. there's a complexity to this, but it's important. So we appreciate what they did, and then we want to talk about what each of their pieces are and why this is so important for us. We need to understand what labor and plaintiff attorneys were looking to do and remove ourselves as being a target for what they're pursuing. As well, I appreciate management. The Cal Chamber Coalition negotiated in a way that thankfully they didn't exclude anybody, didn't allow any employer group or industry to get shortchanged in this. They covered everybody. Our contract lobbyist, RJ Cervantes, is very close with leaders at Cal Chamber, and they were very clear they were gonna take care of every employer group in the country, in the state. But so they wanted to help, but they also wanted to help proactive employers achieve significant protection in this PAGA reform. And it's important for us to see that, what it means and how we can take advantage of that, because that part is not being just given to us. So what did labor want? They wanted more unpaid wages to employees faster. They finally figured out that PAGA is bad for employees. A ton of money gets paid by employers and very little of it actually gets to employees. So they wanted to have employers have much more incentive to cure paying wages directly to employees for any violations. They wanted to make any PAGA penalties, more of the money go to employees, and they got that. One thing they really wanted, they hate arbitration agreements in employment. So they wanted to keep the state Supreme Court ruling called Iskanian that PAGA claims overrule arbitration agreements. And as you know, there was controversy with the US Supreme Court ruling and back and forth, but Iskanian ruling will stay. And we won't mention arbitration agreements anymore because we're talking about PAGA reform right now. But an important note would be, after you go through the PAGA procedures, go back and have a discussion with your attorney, because plaintiff attorneys, PAGA has been a really easy class action for them to file and pursue. That's going to be a lot harder for them now. So they might backdoor us going to a traditional class action. And if we have an arbitration agreement in place, it can eliminate that. So it's an important thing, once the smoke clears on getting maximum advantage of the PAGA reform, do that. Labor wanted to go after bad employers. They finally realized the labor commissioner, through ineptness, is unable to go after bad employers, people that falsify time cards, exploit employees, do bad things. We don't want to defend them. Labor wants to go after them, and they realize plaintiff attorneys nor the labor commissioner are effective at that. And they're doing that two ways. They're now able to go for injunctive relief, which means if they can prove an employer is acting illegally, they can ask a court to stop it, shut it down, change their behavior. And part of why they can do that is, and some people are really concerned about this, that they are allowed now, many unions have set up a nonprofit 501c3 legal aid counseling group to help employees. And obviously it's part of their getting to know employees and helping employees and so forth, and unions pay for that. This will allow those groups to file PAGA claims and get their percentage of fees and minimize the cost for labor unions to support those people. And some people are concerned, well, can they, can unions use those people that harass us? Not really much any different than a plaintiff attorney could before. And again, what they're going to look for is going after the bad actor who gets caught, disappears, shows up as a new name 10 miles down the road. They'll be able to go to a court and say, we're going after the individual employer because they owe back wages, and they can keep after them. So that's what they want to do. And, if we're operating legally and correctly, even though we might make mistakes, we're not going to be a target for those kind of things. That's good on our part. For management, the main points are, we wanted to stop the extortion. As we know, unions in construction, because they are exempt if their collective bargaining agreement is set up right, they're exempt from PAGA claims. So they would, some unions in construction would go to some of our members and say, hey, sign up with us and you'll be exempt. Or if you don't sign an agreement with us in some way, shape, or form, we're going to send organizers to your job site every year and we'll file a PAGA every year on you. We want to stop that extortion. We also want to stop plaintiff attorneys saying, hey, I have an aggrieved employee here. We're going to file a PAGA tomorrow unless you give us $70,000. We have those letters. If an employer is proactive, 95% of that leverage is gone with this reform. That's a huge, huge benefit. Minimizing penalties. Penalties will be substantially reduced, and for proactive employers, they will be greatly reduced. And that's why we're going to talk about how do we become the proactive employer that qualifies. There's an early resolution, and you can imagine this was back and forth. Plaintiff attorneys in negotiating this, they can get a little arrogant in their lower view of employers by saying, we'll give you a deal if you want to jump through some hoops and work hard, because we don't think many of you will. But if you do, if you actually work hard, and we'll give you a process that'll greatly reduce your costs. And I hope everyone on this Zoom makes it, makes them eat those words that most employers won't do this. We want to do this. That's part of what Kyle and Carrie are going to walk us through when they're going through the detail, and you'll say, man, that sounds like a lot of work. Understand that that was back and forth, negotiated hard. Plaintiff attorneys didn't want to make it easy, but they gave us some real options. And then again, one of the main issues is, as you know, courts expanded PAGA over the years, and one employee can represent every other employee for everything. We're back to the aggrieved employee can only pursue those things that are that the employee suffered, and only other employees who suffered that same violation. So what did plaintiff attorneys want? They wanted one thing of low-hanging fruit, and they got it. When they make a pay stub only claim, the process for us trying to get out of it is not very good. So those who have pay stub violations, there's going to be a bunch of plaintiff attorneys who just become like workers' comp plaintiff attorneys who just churn a lot of cases and make some money doing it. Out of 1.4 million employers across California, they just believe I'll find plenty that still have messed up pay stubs, and I'll file claims against that. They also, while penalties reduced, they wanted to be able to go after larger employers. Even with the base penalties down, they can still have some sizable settlements. For instance, just last week, Intuit, that makes QuickBooks, the Federal Department of Labor found they had 2,500 employees that weren't being paid overtime and other violations. That was across the country. If that was California only, an attorney could have filed a PAGA and probably gotten a $6 or $7 million settlement out of it. So they're going to go after larger employers, especially national and international employers who aren't paying that much attention to their California employees, and try and get some sizable settlements. And we won't have to spend too much time on this, but they wanted to make sure if we cure, meaning we pay employees directly, pay all their, back pay plus interest, we're not settling with the attorney. We're paying our employees. So they get to claim what they call lodestar fees, that your attorney will be able to battle how much they spent and what they actually did to the point of us doing the cure. So we need to understand intense negotiations. Everybody got what they want, but I just want us to appreciate what management stood for and what they got. And we'll look at two quick things of that. The penalty structure, which of course is the, yes.
Bruce, this is Kyle. Can we go back to that last slide? I just want to make two comments. The first is regarding the arbitration agreements. I mean, this is very meaningful reform. and I think way more advantageous for employers than for the plaintiff's attorneys. But you cannot rely on this unless you have an ARB agreement, because the plaintiffs can then sue you for a class action complaint in a class action complaint. So it's very important to have arbitration agreements. I mean, it's still an important issue to take advantage of this meaningful reform that's occurred. And just on the pay stub violations, what Bruce was indicating was that there will be a new kind of business plan for some plaintiffs' lawyers, which will go and seek quick, much smaller settlements for pay stub violations only. Fortunately, that's not the majority of the firms that we see day in, day out. Those are bigger firms seeking wage and hour penalties, et cetera. So it's going to be a very limited benefit to have these rules regarding quick resolution of pay stubs, and the fees are going to be way smaller than in a traditional case. That was it.
Okay, thanks. And then who will try and oppose this? Plaintiff attorneys, again, they had to come to the table. They don't like it. I'm sure they'll file legislation next year. They'll get some Democrats to file, but those bills should have no momentum because labor and management are appreciating what they got. And we anticipate, I mean, this could be the law for the next 15 years. And because it was unanimous, because all the parties said yes to it, it'll be harder for appellate courts to undo part of it. Plaintiff attorneys will try. They'll try and push loopholes and see if they get an appellate court to sign on, but likely not that much. So we need to be prepared for this could be the law in the next 15, 20 years. But if we use it right, we can take PAGA claims from a nightmare to a manageable problem. That's our goal. So penalty structure, because this is obviously the main deal, you know, $100 for the first pay period, $200 for each subsequent up to a year. This is where it was so unfair for those employers who paid weekly because their penalties were double those who paid biweekly or semi-monthly. So the new penalty, $5,000 for bad actors or previous citations. For all of other employers, it goes to $2,500 instead of the $10,000 or $5,000. We no longer pay the penalty for paying weekly, but this is what we need to see. For proactive employers, that number goes from $2,500 per employee to $375. So we really want to qualify for that benefit. And again, if we do the proactive part and cure, that penalty can drop to zero. That's cool. Okay. So let's just look at real quick to get that idea of can it go from a nightmare to a serious problem if you're non-proactive to a manageable problem if you're proactive. And it's just simple. I took an example with 200 employees being paid weekly, 200 average employees. And if you have 100 or 1,000, you can just extrapolate the difference. Previously, before reform, the plaintiff attorney was starting at $2 million. And there would be a long and protracted litigation. That's a challenge. That's where the nightmare is. We don't know what this thing will ultimately settle for. It goes on for years, usually. We're spending a lot in defense fees, and there's no light at the end of the tunnel, usually, to try to get to zero or to get to a settlement we can afford. That's where the nightmare is. It takes a toll mentally, emotionally, and obviously financially on the company. If that same employer is non-proactive, now the penalties start 75% lower at $500,000. That's still a ton of money, a lot less than $2 million, and litigation may be reduced, but plaintiff attorneys are going to try and push us and go back to long, drawn out, wear us out, have us spend so much in defense fees, we want to settle. But if that employer is proactive, And that's what Kyle and Carrie are going to show us how we can do that. Our penalties start at 60,000, and there is a early resolution process that we can take advantage of so litigation can be short, it can be clear. That's a huge difference. And I just hope, again, everybody takes advantage of that. So what do we need to do right now? Meet with your defense attorney. And you have to have one who's really engaged in this process. Obviously, Kyle and Carrie are two of those. You can talk with friends if you don't have an attorney you feel comfortable with that. They just have to be really seriously wanting to help you take full advantage of this reform. And because it's hard work, I mean, there's a fair amount of resource time here. You need to give your attorney the freedom to push you. If we say, I think we qualify, don't we? And then if they say, I don't think we covered the bases or this part's missing, we need to listen to them so that we can be that proactive employer that gets the excellent relief this thing can provide. Review with them your proactive options, how you're going to do it, what you need to do. And then it's critical for the early resolution, set up a PAGA rapid response team. This is your team working in concert with your attorney. Everybody knows their job. When a PAGA claim comes in, it's immediately transmitted to your attorney and bells and whistles go off. Everybody says, okay, my job is this. Find out how many employees are actually subject to this. Because again, the aggrieved employee can only represent those who have suffered, quote unquote, the same ostensible violation. And there's an opportunity, and we will be ahead of the curve. Plaintiff attorneys will show up. There's a conference that can be set up early. We'll show up with our ducks in a row, and they will not if we are prepared. And it'll be too hard to do it after. Supposedly, you can still be proactive if you set things up within 60 days after receiving a PAGA, but there's a lot of work to do. It'll be hard. So be prepared to roll up your sleeves with your attorney and take it away. So with that, Kyle and Carrie, take us through.
Yeah, can we go back?
Yeah.
I just want to make a couple of comments on why the timing is so important. As we'll get into in just a minute, you basically, under the new law, you either have to act to get these significant penalty reductions. You either have to act before you get a PAGA notice or a records request, or within 60 days of a PAGA notice or records request. And you may choose to do what's called cure, which we'll explain in a minute. But that is not much time. Anyone that's been in a PAGA case knows how long it is to review records, try to come up with some accounting of what the expected liability is. Usually in days past, there's no way to do it within 60 days. And that's why it's so important to have an attorney who knows your industry, knows your business, knows how you keep records, and has met and done these things before you get a PAGA notice or a records request, which also triggers the 60 days. So it's super important to act early. And that means as soon as possible. Okay.
So we have two quick questions. Brandon asked, what does this do for older cases? We're going to go through that at the end. We have a slide on that, Brandon. Thanks. And then will mediator judge take new lower fines into consideration? Yeah, they have to. This is the law. They can't get around it. On the one hand, going, like we said, from a 2 million fine down to 60,000, they're not going to want to negotiate, meaning the plaintiff attorney, that far off of that. But yeah, it is the law for all new filings June 19 and after.
So just a couple of comments on that. First of all, it's not retroactive, so it expressly has no effect on prior cases. So if you're in a mediation now, the lower fines would not apply. It's only after that June 19th deadline this new law would apply. But as we'll get into in the other there may be some collateral benefits from the new law as a statement of current policy and what's fair. So what's fair will have changed significantly. And that's where the lawyering comes into play. If you've got an existing case, is how you're going to take advantage of the new law, which we'll address in, I think it's the very last slide, but I figured that would be a question from a number of people. So the key provisions are, first, and I'm going to go over these in a summary fashion and then address each one individually, is revised aggrieved employee definition. As you recall, an aggrieved employee to have standing only needed certain limited things: one, be employed, and two, suffer a PAGA violation. The second issue we'll talk about is how to qualify for having taken all reasonable steps to comply. And when we use the terminology all reasonable steps, we use that because that's what's in the new bills. And it's the basis of obtaining a significant 85% or 70% reduction in penalties. But they have to be done early and they have to be documented significantly. And then we'll go over the cure provisions, which reasonable steps are planning to eliminate, basically generally describe it as a plan to eliminate any labor code violations. And the cure provisions are to cure prior violations. And sometimes both are required, sometimes just the reasonable steps is required, which Carrie and I will get into in a minute. There's also an early resolution process. And that's sort of split between those with 100 or less employees during the PAGA period and those with more than 100 employees during the PAGA period. And then lastly is manageability, which up until the Estrada decision was our last defense, stating basically that PAGA claims where they are based on significant factual issues like, did you work overtime? Did you work off the clock? Those could have been determined to be unmanageable and therefore dismissed. But the Estrada changed that. Well, now manageability is back on the table and it's set forth in the statute such that the appellate courts can rely on it. Okay, so now we'll go to each of these and address them individually. Next slide, please. Okay. So aggrieved employee, this is a huge win. And just so you know, my thoughts is this is a huge win for employers in general, this PAGA reform. Anyone that tries to say the plaintiff's attorneys got what they wanted is just, I just disagree. This is a huge win for employers. But it's only a huge win for employers that are what Bruce referred to as proactive. Every one of the deduction or most of the deductions require you to be proactive. This is one that does not. This is just the definition has changed. So before the PAGA reform, the definition of an aggrieved employee was any person who was employed by the alleged violator and against whom one or more of the alleged violations was committed. And those of you that have been in PAGA cases know that that's a significant sentence right there, because they only have to have been employed and have suffered one or more of the alleged violations. In the Huff v. Securitas case, the court ruled that an employee affected by at least one labor code violation may pursue penalties on behalf of the state for unrelated violations by the same employer. In other words, they could go seek out any other violations, whether or not they suffered those violations individually. Well, the PAGA reform bills now states that an aggrieved employee is any person who was employed by the alleged violator, that hasn't changed, and personally suffered each of the violations alleged during the period prescribed under Section 340 of the CCP, which is the statute of limitations. So this is a two effect change. One, the named aggrieved employee has to have suffered each and every of the violations that they're claiming. Otherwise, they cannot recover money for the other employees violations, okay? Before, if you had one, you could assert, for instance, you have a pay stub claim, you could assert any other labor code violation. Here, you have to have individually suffered it. And then the second part of this is the issue with regards to within the statute of limitations. There was some bad case law, I believe it was the Johnson case, that said that even if you suffered the violation outside of the statute of limitations, you could still bring a claim if you were employed and had suffered a violation. So this is a big win. It's a little bit technical, but for those of you that have been in a situation like this, you will know that it is a big win for the employers. Carrie, anything to add to this?
No, we just have the one little caveat that the reform definition doesn't apply when the cases are brought by those nonprofit groups that Bruce talked about. But it will apply in most of the cases that you're seeing, the ones brought by the individuals and that are being pushed by the plaintiff's bar.
Right. Okay, so the next slide. So this emphasis on proactive compliance, you know, we went back and forth. Do we tell you what the reductions in penalties and the ability to cure first, or do we do it secondly? We decided we would go with just emphasizing the proactive compliance. This term, proactive compliance, basically means that you've taken all reasonable steps to be in compliance with the labor code, even if violations occur. So as we'll discuss later, to obtain the 85% reduction in PAGA penalties or the cap of 15%, whichever way you want to state it, you have to have done this, basically taken all reasonable steps to be in compliance. The two bills define these steps as including, but not limited to, periodic payroll audits, distributing lawful written policies, meaning don't have any facial violations in your handbook, training supervisors and disciplining supervisors. So these are the things that, as we'll get into later, you have to do either before you get a PAGA notice or a records request, or after you get that PAGA notice. If you, in that case, you will get a 75% reduction. Correct? 75?
70.
70, 70, with a cap of 30. So reasonableness depends on the totality of the circumstances, which is a term previously defined in the law for many other issues. And basically, they will look at everything. They will look at your size, your resources, your ability to do an audit, the nature and severity and duration of the violations. Did they exist for a long time or a short time? So all of these things are going to have to be reviewed before you get a PAGA notice or a records request to obtain the 85% reduction, or within 60 days after a notice, a PAGA notice or a records request. So that's why we're emphasizing how important it is to be proactive, meaning you need to act before you get the notice or the records request. You need to act now. Okay. Next, Carrie, anything to add here?
Just that I fully agree that with everything we're going to continue to emphasize, that the greatest options, the greatest benefit for you are available the sooner that you start to act. But I also want to emphasize that it's never too late to get some benefit. So for example, to qualify for those specific reductions Kyle's talking about, those have to do with when you got a PAGA notice alleging the specific violation at issue. But if when you get that first PAGA notice that alleges a handful of violations, you then still have the opportunity to take reasonable steps with respect to any other violations you may be experiencing, and you could still qualify for the greatest reduction there. So in other words, if you spot them now before the plaintiff's attorney starts doing discovery and spots them and then files an amended notice, you're still ahead of that notice. So it's this process of not only being proactive today, but remaining proactive during these periodic audits, as new things change, as new laws come out, staying on top of these things consistently So as much as I 100% want to agree with and emphasize, the employers in the best position will be the ones who start today. We also have to stay on top of it. We have to keep up as things change, and remain proactive moving forward as well.
And I want to make a real quick point. In the negotiations, you can imagine plaintiff attorneys said, if we're going to give you this great benefit, you can't have a violation. So if we find a violation, I can blow up all your benefit. And somebody had to push back hard to say, no, we can take all these reasonable steps, but you know, the labor code's over 1,000 pages and there's dozens of court cases interpreting it. We could still make a mistake. And even if that happens, if we've done all these things and can document it, we still qualify for these tremendous credits. So again, appreciating the negotiators standing tall and keeping this provision in line, because as we know, trying to be, you know, the idea that we could be perfect in everything is just not fair.
That's a perfect transition actually to our next slide, because we're going to talk about issues related to the cure provisions. So as Kyle said, the #1 goal is to be proactive employers, which means we're doing everything we can to comply to stop the violation from happening in the first place. But as Bruce just mentioned, even with our best efforts, sometimes there may still be violations. We could have mistakes. We could have something that just wasn't caught. We could have the reason for the discipline being one of those steps is maybe you have a rogue supervisor who did something wrong, and before you could catch and correct it, some violations occurred. So what options do we have now to still take advantage as much as possible of the reform? And that is that the reform also provides for caps on penalties or reductions in the penalty amounts for employers who cure violations that do exist. And the statutes say that to cure a violation generally means that you correct the alleged violation, you bring yourself into compliance with the underlying statutes that were in the PAGA notice, and that each aggrieved employee who suffered a violation is made whole. Again, we're focusing on being proactive and on that rapid response team, because we only have 33 days from the postmark date of the PAGA notice to take advantage of the cure provisions. And again, that's from the postmark date of the notice. These have to be sent to you by certified mail. So the good news is they're generally not arriving way later than that. But this is part of that setting up that PAGA response team. Who's going to get this mail? Who knows what these notices look like? And what tricks may be played to try to keep you from realizing that the bells and whistles should be sounding, that you should be acting. So that's something that you need to discuss with your attorney, discuss with your response team. Who's going to get the notice? How are they going to get it into the hands of the decision maker and your attorney as soon as possible, so that you can look at the violations, see whether any occurred, what cure steps you may want to take, and whether it makes sense based on what's being alleged. If you do so, you have to cure within 33 days and then give notice of the cure to the LWDA and the aggrieved employee who sent the notice. The employee does have an opportunity to dispute your cure, so you actually have to do it. What we say we're doing and giving them notice, we have to do it, and we have to be able to back it up if there is a meaningful dispute. They do have an opportunity to appeal. The LWDA gets to review the cure and can give you a grace period. They could say, hey, I don't think that you've cured yet, but I'm going to give you 3 more business days to do these additional things I need you to do. Again, 3 business days we're talking to be able to respond to something. So we have to be on our A game here. Generally speaking, an employer can only cure the same violation once per 12-month period. So once we fix it, again, we remain proactive. We make sure it doesn't happen again, rather than just saying, okay, I cured it, my penalties are down for this claim, moving on. We stay on top of things, we stay proactive.
Can we go back just real quick? Clayton asks a good question. What's the best way to prove, talking about the reasonable steps, what's the best way to prove all these steps are taken? For example, how do we prove we've disciplined our supervisors?
So I'll start general, and I say the best way to prove these things is to document it. If you're writing up a supervisor, that goes in the supervisor's personnel file. It's also, if I'm that attorney that you're talking to, it's also going in your separate all reasonable steps file that you're going to have handy. So we're going to make copies. We're going to document things. That's how we prove that we did them. They can be proven through testimony and things like that. But my number one question, if any of you tell me you did any of this, is going to be, what do we have to show that? If we're training people, are we having them sign in? Do we have other records that show the date, time, and content of that training? Just like with your safety training. What records would you have to show that you had a specific tailgate meeting? What topic was discussed? So those are some ways that we prove generally that we did things, is what documentation and support do we have for them? Beyond that, I'll say it's going to depend a lot on what actions we're taking and what violations we're trying to combat. In terms of a payroll audit, those produce lots of documentation and show what happened and when. But we also can specifically create records that show, okay, these are the employee records we looked at. This was the scope of the audit. This is how often we decided to do it. So this, not only when you're discussing with your attorney, with your response team in general, what are we going to do to take all reasonable steps? Part of that discussion should properly be, and that's a great question, is how are we going to document and keep track of what we're doing?
And I think part of the question, I think, from Clayton, it's like with Cal OSHA violations, the independent employee action defense, we have to show we have, disciplined employees and supervisors, and it's like almost like a quota system. What if, so are there ways, for instance, because you don't want to make supervisors mad by saying, well, we have to discipline somebody, you have to have something in file. Can that be as simple as a verbal, kind of warning, don't do that again, that's documented in file?
You said my favorite words at the end there, Bruce. Yes, if it's documented in a file, that could be appropriate corrective action, depending on what the issue was with the supervisor. And that's always part of any discipline decision. It's, is this enough? Well, it depends. Has this person had prior violations? They've had 3 other verbals in their file and you just want to throw a 4th on the pile? Or is this the first time that this person's ever had an issue? So those are the kinds of things we'd need to look at and discuss in a particular situation to say, this is the right corrective action, but absolutely agree that a verbal warning can be the appropriate corrective action, and that if that's what we're using, we do need to document that as well.
Okay.
Yeah, I just add what Carrie just said is basically you're going to need a proactive steps outline with documents needed, schedule audits, conduct audits, review handbook policies, have advice from the attorney on that regard, take and document any corrective actions. There's going to be a whole list of things to show that you're being proactive. And the documentation, as Clayton mentioned, is going to be significant. And keep in mind that if you do that before you get the PAGA notice and or records request, you get an 85% reduction in PAGA penalties, which is gigantic. It's huge. It's very important. So it's definitely worth doing this. And then taking it a step further, is that I still believe that given these short deadlines, that a lot of these cases are going to be negotiated in settlement, because some of the plaintiffs' firms are not set up to do this basically speed settlement or speed resolution. They're just not. They have too many cases, the bigger firms. They don't have the right people to do it. So the fact that you did something either in the proactive stage before the PAGA notice or after you receive the PAGA notice is going to be used by your defense lawyers to defend you. Okay.
Okay. We have a couple of good questions here. So Marissa asks, we look at our time on a weekly basis for things like missing or short break, days under 4 hours, etc., so we can make corrections or pay penalties owed. Does this count as a payroll audit? In other words, doing your own payroll audit or do you need an outside person to have done the payroll audit, is my addition to that question.
So it certainly can be argued to be a payroll audit. I sure as heck would argue that it is one. The question is that payroll audit all reasonable steps that a particular employer should be taking? And as we saw on the slide that Kyle went over, that depends on the totality of the circumstances, including your size and your resources. So for a smaller employer, it may be perfectly reasonable to only do internal audits and not work with an outside firm to do that. For a larger employer, courts, plaintiffs' attorneys, mediators may be looking for more outside involvement. I can say offhand, the fact that you're doing this on a weekly basis is already going to put you far ahead of a lot of other employers who are going to look at periodic and say, how far can I possibly go before I have to do another? So that's where there's a lot of room for argument here. And I certainly, again, if I'm defending this claim, I'm going to emphasize, look, this is something that they're actively doing every week. That's as proactive as it gets. And the other side might say, well, they could have hired an outside person. They could have done more. So the key is really that when you sit down with your attorneys, with your other professional advisors, like an accounting firm, like whoever else may be involved in these decisions for you, is to give them all of the facts. They need to know what your resources are. They need to know what your average payroll is in terms of employees, in terms of dollars. They need to know what you're finding when you're doing these things on a weekly basis. Because if these weekly audits are effectively solving the problem and we're not continuing to see them, it may be reasonable to keep them at that level. If these weekly audits are turning up consistent problems, reasonable steps may mean we need to take these to another level. So it's really just going to depend on all of those factors, including what you find. But absolutely, that's at least the umbrella I would put that in when I'm arguing that you did take those steps.
And it's good. Marissa talked about they make corrections or pay penalties owed on the spot because
Yes.
the statute says make corrections based on your audit.
On
Right?
what you find, exactly.
Yeah, I just want to reinforce the fact that's going to depend significantly on the accuracy of those audits. I mean, you may miss a couple here and there, but if there's a regular reoccurring violation that you're not spotting that someone else may spot, that could be problematic.
And then Alvin asks a question, is there a statutory period for an employee to file an appeal to the cure?
So it depends on which type of violation we're curing, which cure process we're using, which is triggered by what size of employer we are. Generally, they're relatively short periods for the employer to do the initial dispute of the appeal. The time to explicitly appeal a final cure decision by the LWDA to Superior Court is not contained in this statute explicitly. But on the initial dispute, they have a 21-day response time to say, hey, we don't think that they cured. So very short period to dispute. The actual appeal itself is going to be it looks like is going to be determined by more standard appeal deadlines, not one that's specific to this statute.
Yeah, and I just might comment that I think we said that the employee could appeal. Well, the employer can appeal a proposed cure that's rejected either by LWDA or by the plaintiff's bar or the plaintiff's attorney. So it goes both ways. Okay, Carrie.
Okay.
Yeah.
And then Cheryl asks, what is the look back period that we are dealing with currently, statute of limitations? Because I think, Kyle, you talked about that, did this change that look back period in any way?
So it did not change the statute of limitations, the look back period. By default, it's 1 year. Things did get a little weird for a while with the COVID tolling thrown in, but we're past all of that. So for any new claims, that should not be kicking in. And we're looking at 1 year going back. And then as a reminder, because we always have to remind you of the bad things as well, PAGA claims continue moving forward. So it could be more than a year worth of relevant period by the time that you get to a settlement or a resolution. It's 1 year backwards.
And I'm just going to...
Backwards is from what?
From the
notice?
filing of the PAGA notice.
Right. I'm going to make it a little more complicated because it is with regards to the cure for wage and hour, you have to cure going back 3 years if you're choosing to cure. So that's obviously a decision that needs a lot of analysis, before you do that, because you would have to cure going back 3 years for a wage and hour claim. Right.
Plus interest. And that's why if someone really qualifies for the proactive, take all reasonable steps, and that penalty is $375 per employee, you can kind of balance that on what is curing going back 3 years plus interest going to cost me. And obviously also the logistics of reissuing paychecks.
Right. And
Okay.
just point is you don't always have to cure. You can still be proactive and not cure and get some benefit and some penalty reduction. Curing is just another aspect that gives you more significant penalty deduction.
So here's the next slide.
Okay, so on the topic of curing, we talked a little bit about the general cure process and provisions, but I want to dig into a little bit of what curing looks like for specific violation types. So under the reform statute, they've clarified what it means to cure certain types of violations. To cure a pay stub violation that's limited to an incorrect employer name and/or address. You can cure by providing written notice of the correct information to each aggrieved employee, so each person who got an incorrect pay stub during the relevant time. You can do this in a summary format as long as it's broken down by pay period. So you may be able to avoid issuing new actual pay stubs and could use a payroll report, so long as it was broken down properly and included the right information. To cure a different type of pay stub violation, you have to provide fully compliant itemized wage statements, so a new pay stub, to each aggrieved employee for each pay period. You have to go back 3 years prior to the notice for this type of cure. And the one that's generally going to be the toughest to do within the time frame, and as Bruce and Kyle mentioned, it's a strategy decision whether you want to. But if you did want to cure an unpaid wage violation, you can only do so by paying the full amount of any owed unpaid wages that are due to each aggrieved employee. You have to go back 3 years before the date of the PAGA notice. You have to include 7% interest on those unpaid wages. You have to include any liquidated damages that are required by statute. So that's generally going to apply if we're talking about unpaid minimum wage or unpaid overtime. And then for your cure to be accepted, you're also going to be responsible for the reasonable lodestar attorney's fees and costs. Those are determined by either the LWDA or the court. So you just need to understand that part of your cure is going to be paying those as well, but you won't be able to determine yourself what amount that is.
Yeah, and Carrie, maybe you can talk a little more, about just how difficult and specific this is going to be based on what the labor code violation is. If we're talking off the clock work, it's going to be next to impossible to go through all of the records for 3 years and determine who may have worked off the clock work. One, we're not going to have that information likely.
Yeah, there are definitely
difficult.
Certain theories and certain types of violation that are going to be more susceptible to cure. And there are going to be ones that are a lot harder. We see very often in PAGA claims, especially in the construction industry, these allegations of off the clock work. And by their nature, those are going to be very difficult for an employer to quantify and cure, because the argument is we don't have a record of that time that was worked. So those are going to generally be more difficult to cure. Again, depending on your specific facts, we may still be able to. It's something to take a look at, but could be a stronger challenge. Whereas, for example, if somebody argues that a specific type of compensation wasn't included in your regular rate of pay and should have been, if you meet with your attorney, you confirm that that's accurate, that's math we can do. We can go back and see what did we pay, what should we have paid, and then determine whether it makes sense to go in and pay that. Or another example would be like on a pay stub violation. If there's an allegation that we did the math wrong, there was some form of clerical error, that might be fixable. So it's going to depend a lot on the facts and theories that we receive. And as Kyle mentioned, one of the big challenges there is that we often don't receive the facts and theories that the statute says that we're supposed to, which may give us defenses to the claim later, but it makes it more difficult to take advantage of the cure up front if we did want to. So those are all things that you'll have to review with each notice, each claim that you get, and see, is this a violation, one that makes sense to cure? And that's where I also want to point out that this is on a per violation basis. So you may get a PAGA notice with 10 violations and decide you want to try to cure 3 of them and not the rest. And that's a decision you're allowed to make. There is no admission of liability by curing a violation. That's specifically in the statute. I think most attorneys will probably be writing disclaimers like that into the notice of cure anyway. So that is in the statute. If the cure is ultimately overturned, so the court or the LWDA finds that your cure was ineffective, you do get an offset for the amounts that you paid through the cure, to offset the eventual liability that is found, if any. So just some important provisions there to keep in mind when you're analyzing these as they arise and seeing, does this make sense for us? Is this something that we'd like to take advantage of?
And Carrie, just while we're on here, the cure is different than the proactive 85% reduction, correct? So if you took some efforts to significantly minimize off the clock work before the PAGA notice, you may be entitled to the 85% penalty reduction.
Correct. These are not dependent on each other. We'll re-review the penalties again later, and you'll see the greatest benefit is where we have both that meet, where we took all of the steps up front, and then anything that slipped through the cracks, we did cure once we got notice. That's the way to reduce your exposure the most. But you are absolutely welcome and encouraged to do either one. And again, to be constantly evaluating, does it make sense to do one or both here?
And it adds to the point of, we talked about the employer establishing a rapid PAGA response team so that somebody's digging in to give enough information so we can make qualified decisions when we're doing this. So we have a couple of more good questions here. Someone asked, could we provide an example of liquidated damages required by statute?
Yes. So if there is a minimum wage violation, the statute says that you owe liquidated damages on top of the minimum wages. So whatever amount you underpaid, liquidated damages double that amount. So if minimum wage is $15 and I paid somebody $10, I would owe them the $5 I didn't pay for that hour. I would also owe them liquidated damages of an additional $5 per hour as punishment.
And then Cheryl asks, how specific are the claims itemized on a PAGA claim notice? Do they say what, when, who, or are they just a general meal break violation statement? I know this is a real frustration that they are pretty vague, but go ahead.
They are supposed to include all of the facts and theories on which the violation is based. So they should be telling you, these groups of people had this violation, here's how it happened. The majority of the time, that's not the case. Case law has been relatively lenient, but there are cases where employers have prevailed and said, look, we weren't given notice of what we're doing wrong. We don't have the chance to defend ourselves. But again, from a practical standpoint, most of the notices that we're getting are much more vague. It says, you didn't give me a compliant meal period, including without limitation to, it was late and or short and or combined and or my supervisor yelled at me. So they certainly don't have the specifics that I think we all would like them to actually solve violations and stop them from happening. There is at least some hope that that could change with, these movements to say, how do we bring this statute back to benefiting employees and not just generating attorney's fees? Those types of notices I think employers are, and defendant employers in particular, are going to be pushing a lot harder to say, I was robbed of the opportunity to cure because you didn't tell me what I was doing wrong. So I think those issues are going to continue to play out for quite some time.
Yeah, I'm going to add here, because this is a huge pet peeve of mine, and Carrie and I argue about this, we commiserate over this all the time, is that there's not enough information in the PAGA notices. And Carrie's going to comment about the early evaluation conference that's held in court. And that may be the perfect time to bring up this lack of facts. The plaintiff's actually required to do certain things to provide facts to justify the full amount of the potential penalties. So they did try to get something in the bill. I think it just applies to 100 plus though.
For those to be mandatory. So yeah.
Another question, the labor monitoring agencies employed on public works projects, they do review and accept our certified payroll reports. Will that qualify as any proactive qualification for penalty reduction? Like, is that part of our audit? How would you present that?
So I absolutely think it's a helpful fact for employers. And we don't hesitate to bring it up when it applies. I would generally not say that's going to get you to all reasonable steps. But if that is one of the many steps you're taking, that's a wonderful thing. And I think it's something that you need to bring to your attorney's attention, make sure that they have that ammo to use for you.
Okay, ready for next slide?
Sure am. Okay, so we hinted a little bit about the early resolution process. This is generally broken down by whether you have 100 or more employees, and this is total employees during the relevant period, which again is usually going to be the 1 year back from the PAGA notice date. So did you employ a total of 100 or more humans during that time period, even if one of them only worked for an hour, even if some of them are part-time? None of these don't have to be full-time equivalents. This is just people employed, the grieved employees. You can request an early evaluation conference and stay the court proceedings, which means we're not starting discovery. We're not starting a bunch of hearings with the courts. We're not doing all of the things that make litigation quite as stressful as it can be. We've still got some work to do, certainly, but we're avoiding really kicking that full litigation machinery into motion, which is that high burden and that high cost that, like you said, Bruce, really can wear people out. So this is our chance to stop that very early. This is filed by your responsive pleading deadline. So generally about 30 days after you're served with the complaint, you file this request and you say, hey, court, we're not going to go any further with litigation. I want an early evaluation conference. That conference is then scheduled with a neutral evaluator as soon as possible, has to be within 70 days. So again, we're talking tight time frames under the reform statutes. The plaintiff and defense both submit statements during that time period. This is where Kyle was just going with saying the plaintiff is required to specify the facts that they have. This is where I get a chance to say, you told me meal period violations. What was it? If they're late, who made them late? If you were missing them, how often and when? This is where we get to put it on them to provide us more specific facts in the context of this settlement conference. I certainly am still reserving the right to argue that those should have been in the notice in the first place, but practically speaking, this is my chance to get them one way or another. The defense can also submit a cure plan if applicable. If there are violations that we plan to cure, we submit that cure plan confidentially as part of this process. If we have less than 100 total employees during that, yes.
Stop here just because this raises all kinds of questions that I know you and I have talked about. But the conferences with a neutral evaluator, who the heck is that person? Is it someone associated with the court? Is it someone at JAMS? It's supposed to occur within 70 days. You couldn't get any arbitrator or mediator at JAMS within 70 days, or probably likely anywhere else within 70 days. So there's a lot of unknown here. And also there's some provisions that says that the plaintiff's attorney and the defense attorney can change the schedule or the process if they both mutually agree. So likely we're going to see a lot of change in this area, but this is what the statute says.
Okay, we had a quick raised hand. I'm gonna give Kirk. Do you want to talk?
Oh, sorry about that. I thought I turned that off. Basically, the question I had was, when you say 100 plus employees, are they active employees? So if you have, 98 active employees and 10 during the year that term, but you never got over 100, that does not count, correct?
So that will still count as long as you employed 100 or more people during this entire period. They don't all have to be active at once. Even if they didn't work that entire time, but you employed them, there's an argument that you could be in here, and that's something you'd want to look closely at. Like if somebody was employed by you, but was on a leave of absence that entire time period, which would be a very long leave, but we've seen it happen. That's something that you'd want to look at closely, but at least in the plain language of the statute, that would count. You would qualify for the program.
Okay, got it. Thanks.
Okay, and so then let's talk a little bit about the process. If you do not have 100 or more total employees during that time, there is an early resolution and review process provided through the LWDA instead of through the court. And so for that one, within 33 days of your receipt of the PAGA notice, you can submit a confidential cure proposal to the LWDA. LWDA then has a review process. They'll notify you within 14 days if they would like a conference to learn more about your cure plan. If so, that conference is to be set within 30 days. Again, this is all internally within the LWDA. The employer's cure, if it's approved, is to take place within 45 days. The parties do have some room to set deadlines within those parameters. You have to submit a sworn statement that you did complete the cure and a payroll audit. The employee can dispute the LWDA's preliminary determination that the cure is appropriate and request a hearing with the LWDA. The employee also has the ability to appeal a final determination of cure, and that appeal would be heard in court.
So I just add, just like my question to my issue with the last 100 plus employees, Bruce, I believe you said that, and I believe it's true, there's no additional funding to LWDA to handle this process. Is that right? That's
correct.
So where are they going to get the people to handle these cure hearings, or, the decision on the cure? That's my question. I noticed when we were at Ledge Day, LWDA was hiring, and there were big billboards from the airport into town, but I just don't know how this is practically gonna move forward within the time constraints. And then what's the ramification of it not moving forward within the time constraints? Those are all issues that we don't know the answers to.
Right. And again, because as we've said, this is cumulative employees, someone who has 70 employees on average, but has 120 W-2s at the end of the year, they are 100 plus. So it's going to be fairly smaller employees that, depending how often they're a target for PAGA claims. But yeah, if you qualify for less than 100, the LW Labor and Workforce Development Agency process, that could get slowed down significantly just for lack of personnel. And that is not included in the employer surcharge that pays for the agency below LWDA, the Department of Industrial Relations. So that's to be worked on.
Okay, and then I think Kyle was going to work through some of the penalty calculations.
Okay, so there are significant changes in the penalty calculations. The original default penalty was 100 per violation, per initial violation, and 200 per subsequent violation. That was always a hot topic in mediations. Are these subsequent violations? Luckily, most of the mediations say they're not subsequent violations, but the case law didn't necessarily give us a final answer to that. So the good news is Under the new bill, it's $100 per pay period. And then there are other particular penalty charges that are more specific and less than original. $25 for most wage statement violations that do not prevent an employee from determining accurate information. For instance, the name and address of the employer is often brought up, and things like that. So if there's enough information that the employee is not prevented from determining the important material information, the penalty will only be $25. I covered number 2 already. $50 for isolated non-reoccurring events that last no longer than 30 or 4 pay periods. That might be for, issues related to a rogue supervisor, issues that change when you change penalty or payment companies, etc., or go from paper to electronic. So there's reduced penalties for short violations. And then the carrot, I guess, is $200 for the plaintiffs, is $200 for repeat, which is defined as within 5 years, and or malicious, fraudulent, or oppressive violations. So there is some, that was a bone, I guess, they threw to the plaintiffs' attorneys to go after bad actors, basically.
And we understand, the malicious and fraudulent, but the 3 of us talked about the repeat. That the repeat is triggered by a bad settlement by the attorney, because it's where LWDA or a court finds you in violation. So that's part of your settlement process, that your attorney needs to not allow you to be found in violation. Is that right?
Yeah, absolutely.
Okay. Either a bad settlement or a failure to settle when you should have, if there was a known issue that you could have settled with a non-admission of liability and avoided this, but perhaps you choose to fight a fight you should not have fought, and end up with a bad finding against you. The next time around, you could be in repeat territory.
So that's part of the analysis. And the other part of this, to just confirm, is the $100 per pay period is cut in half when we pay weekly. That the inequity in doubling penalties for those that pay weekly has been eliminated, and that's a big help for us. And there is a question: can we have our mailing address PO box on our pay stubs rather than our physical address?
Good question.
Federal courts so far have said yes, but there is no published binding state court decision on the issue. The statute itself just says address. It does not say street address. It does not say mailing address. So there's an ongoing argument about it. So far, no case has explicitly said, any published decision anyone can rely on has explicitly said a PO box is a violation. And there are at least 4 that I've found, federal trial courts, that have said PO box is just fine. So it's an open issue, and something you really want to look at. Again, let your attorney know those facts. Do you have a physical address that could be provided, or do you operate without a physical working location? What mail is processed at that PO box? What is it for? Could be a relevant fact as well to go over.
But I would point out, and Carrie, let me know if you disagree, but this would be an issue that can be cured with no penalty under the cure process. It's super simple.
Agreed. This is generally going to be one of the easiest ones, and this is one where you could be issuing a summary report rather than full pay stubs. So still some work involved, still got to move quickly to do it, but one of the more doable cures for sure, if it is ultimately found that does create a violation, if that law changes or is clarified.
And a quick point is that when you talk to some labor commissioner deputies and leaders and labor and workforce development agency people, they believe you need the physical address, because if an employee disputes their pay, they need to know where they can go to dispute or get things corrected. And many employees work remotely, hired remotely, and don't even know where the company headquarters is. So it's generally safer for defending against those people to have a physical address. Okay. Next slide.
So another good issue that's often a topic is in mediation is the new law clearly does away with derivative penalties for most common wage statement and untimely wage payment claims. This was referred to commonly as stacking. So this new law confirms the court's authority to refuse to stack penalties for multiple violations arising from the same conduct or omission. So for example, an issue such as unpaid overtime, there can be no derivative penalty for a wage statement violation for that issue. That's a big thing. It documents the problems.
To just expand on that example that Kyle gave, the plaintiff's bar was notorious for arguing, okay, this person worked 10 minutes off the clock and that was overtime work. So that also means we have a record keeping violation and a pay stub violation. And oh, you fired that person last week, so now you have a waiting time penalty violation. This confirmed the court's authority to say, I am not issuing 5 penalties for that one single act that you did, which was not recording 10 minutes worked. And so this is just clarified and given us more ammo to fight against those practices. On the other side, this is going to, the plaintiff's bar, I suspect, is going to pick up strongly on this and say, okay, this means we can stack violations for separate conduct, which was is still and was a gray area. So in other words, if I have a meal period violation and an overtime violation in the same pay period, can there be 2 penalties for that same employee that same week? And that is still an open issue. And I think that they will use the fact that the reform measure clarified that shouldn't happen for one act. They'll push and say that means it should happen when there are multiple acts.
Yeah, that's a good point. Clearly, the plaintiff's attorneys are going to fight for any way to increase the penalties given these significant reductions, and that's definitely going to be one of the areas. Okay, I think we're ready for the next slide.
There you go.
Okay, so here's kind of the overview of the significant benefit of the legislation. The first is for those that utilize weekly payroll cycle, you get an automatic 50% reduction in the penalty. That's huge, and it made no sense before. And I think everyone agrees now that it didn't make sense. And this we'll discuss later, while this is not applicable to cases filed prior to June 19th, this is a fairness argument that goes into the judge's discretion when reducing penalties. But it just makes sense. You shouldn't penalize companies that utilize a weekly payroll cycle as opposed to a biweekly or bi-monthly cycle. And then the second reduction is the most significant, which is compliance before the PAGA notice or a records request. And I want to point out the records request. All too often we'll get a client send a records request and it's been 2 or 3 weeks since they received it. Well, we may not have a chance to comply if we get it. And that's really, it's important. So any PAGA notice or records request needs to immediately be communicated to your lawyer. So this 15% penalty cap occurs for any reasonable steps that we take, for the reasonable steps that we take before we get the notice or records request. So that has to be done immediately, okay? And we talked about how to do that previously. And then there's another reduction where you do the compliance steps within 60 days after the PAGA notice. And that caps penalties at 30%. So that's a 70% reduction. So you can see that's a significant reduction if you take the proactive steps that Bruce was talking about earlier and that we just went over. And then there's compliance steps and cure, which as to wage and hour claims would mean paying whatever amounts are due to the employees going back 3 years. There would be no penalty for those compliance steps if those cure steps are taken. And then the cure of the pay stub violations, again, no penalty if you timely cure those pay stub violations. And then lastly, the cure of other violations, there's a $15 penalty cap on those. So as you can see, this is a definite benefit to an employer, especially in a mediation where there's still some ambiguity as to whether the compliance was, perfect or not, whether it may qualify at the time of trial if you get there, but it's important to do because of these significant reductions. It just so drastically reduces your potential exposure that to not do so would, to me, seem not smart.
And we have a question from Marissa. This goes back to the multiple violation issue question. What if one act causes another? For instance, if somebody claims they clocked a break, but it was interrupted, now they have a break violation, and those extra hours we didn't know about causes OT. Is that two separate violations?
That's
so
a
that's
good
certainly two separate violations, but whether those two violations were caused by the same conduct of the employer for purposes of stacking is, I think, as Kyle was going to say, that part is a little bit more subject to debate. I would argue no, because the act of the employer is the interruption of the break. But the plaintiff's bar is certainly going to try and argue yes. So that's where the debate would occur, is whether those violations were caused by separate acts.
And the cure would mean you'd have to pay a overtime premium, arguably, for those extra hours, or no?
For the cure, yes. If those extra hours would have been overtime hours, then to cure that wage violation, that would have to be at overtime rates with liquidated damages and all the other lovely things that went on that slide.
Yeah, and I'm just going to back up because I think it's important. The compliance before the PAGA notice requires the employer to take all reasonable steps to be in compliance with the labor code sections identified in the request or the complaint. And then you get the 85% reduction or the cap of 15%. So to have that argument in your, basically on your side at the time of settlement discussions or mediation is very, very important.
And just going back to what we talked about, the court has authority to refuse multiple violations arising from the same act or omission, and that's what you're going to push for, right?
That's right.
Right.
We would argue that that's the same act or omission.
Okay, and then we have a question: documenting informational cures, certified mail, employee signature. What proof of cure is acceptable?
It's going to depend on what exactly it is that we're curing. Is this a current employee? Is it a former employee? Do we have verification of their mailing address in some way, shape, or form? So what is going to cure the violation is going to depend on all of the facts surrounding the violation, but primarily on what the alleged violation is.
Okay.
Right. So we talked a lot about what members can and should start doing right now, but we also wanted to talk about what members need to avoid doing. And I should say what also our guests on the webinar should avoid doing. Avoid pay stub violations. Those are and continue to be the low-hanging fruit. We got a lot of help here in options to cure certain violations and in more appropriate penalties for some of those violations. But at the end of the day, avoid those facial violations that very easily fall into the hands of plaintiffs' attorneys. And as Kyle and Bruce discussed a little bit earlier, we may well see an uptake in firms that either solely practice these types of claims or gain a specialty in these types of claims and bring more of them. Again, it's just such an easy one for them to find out about if they are happening, because pay stubs are out there. They are floating around. They're often, if anything, the only employment related document that your employees have handy. They generally aren't walking around with copies of your handbook or other things that could reveal violations. So these are sometimes the highest risk violations, and we really want to make sure that we're avoiding those, taking those reasonable steps now to make sure that our pay stubs are in order. You want to make sure that you're avoiding prior decisions by the LWDA or courts, obviously, if those decisions might be against you. You do not want to get into that repeat violator category where all of your penalties are back up to being larger amounts. Avoid the bad behavior. Don't be the bad actor that also increases those penalties. Don't be the bad guy here. Taking those malicious, those intentional bad acts, trying to cut corners, trying to do wrong. Probably not the people who are on this webinar, because you're already doing the right thing by being here. But again, just reminders. And as you talk to others in the industry about this, this is really the key, is to avoid that bad behavior, which is not going to be looked favorably upon by the courts if you try and ask for any other penalty reductions, but it's also going to keep you out of all of those reductions that we outlined and put you in that $200 per violation category. And then avoid delayed responses. The biggest thing that this reform measure gave to employers is options. You have a choice to take these compliance steps at various times. You have a choice to cure certain violations. You have a choice to participate in these programs. And in some cases, you may decide not all of those choices make sense for you. But if you delay, if you're not set up for success in the beginning, you will eliminate those choices for yourself before you even have the chance to take advantage of them. So start getting things in order now, start identifying that team, start finding an attorney who you trust, who you know will work with you through these problems and who understands those practices, and take the time to educate someone about your practices, to tell them when something changes, to tell them when problems arise so that they can help you work through them early. The delayed responses will really close a lot of these doors for you that these business groups fought so hard to open. So don't close yourself out of the relief by being too late.
Two questions. Clayton asks, does having a smartphone-based timekeeping system cover most of the time-based violations we're talking about here? From my limited understanding, if an error occurs with timekeeping, it would be on the employee to keep that accurate.
So
No.
a couple things to say. First and foremost, accurate timekeeping is always, 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 always the employer's responsibility. Having electronic timekeeping may help you meet that responsibility, but having the system alone does nothing for you. Properly setting up the system and your corresponding policies, following up on issues that you're seeing, that may get you a whole lot of the way towards reasonable compliance steps. It certainly makes the auditing process much easier and can put you in a better position to be able to take the steps. But no smartphone, no app, no payroll company is going to do this all for you. If you want to be a proactive employer and get the benefits that go with that, you have to be proactive every step of the way. It's interviewing the timekeeping companies and seeing, what can you do for me? Do you work with construction? Do you understand my issues? It's telling them, give me a copy of every single thing that's editable in this system and allow me and my team to go through and edit them. It's making sure that they have systems that are set up for California and not just default rules. It's seeing what settings can I change and what settings are you assuming that I want that probably I don't. And that may be generating violations for me that I don't even know about. So just like with a paper timekeeping system, having a paper timekeeping system is not a violation. How you implement it and carry it out and use it can result in violations. Absolutely the same is true for electronic timekeeping. I will say there are several judges, mediators, plaintiffs' attorneys who will look favorably on the fact that you have an electronic timekeeping system. They do see that as a step in and of itself. And I will absolutely encourage them to see that way if it's one that you have and if I'm your attorney. So I don't want to downplay that it can be incredibly helpful, but you have to put in the work to make sure that it's set up right and that it's doing it for you. That's similar to a question I get asked all the time of, does I have an employee handbook? Isn't that enough? No. Is it up to date? Does it contain the correct policies? Is it California specific? Is it construction specific? All of these things matter. So having the tools is absolutely a start. And kudos if you've done that, if you've looked into it, but you've really got to take these proactive steps to look at the system and say, am I using it right for me?
Okay, Alvin asks, what are the legalities of providing electronic self-service pay stubs?
Are we talking about electronic access to pay stubs? I'm going to guess that because that is a question I get a lot. So like the pay stubs are provided to employees electronically. That's generally legal so long as you meet certain requirements that they have agreed to it, that they have noticed, that there's a way for them to get printed copies for free if they request them. How do they do that? Do they know how to do that? So there's some steps that need to be taken, but generally that can be done if that's what I hope the question is.
And Carrie, that assumes all of the information is on, the required information is on the pay stub, correct?
Correct. I'm talking about just method of delivery, not content.
And I believe there's something in the code that says it's supposed to be on one sheet of paper, which is also a problematic issue, maybe a problematic issue with electronic timekeeping where the access may be multiple windows or views. Just issues you should think about.
And then Natalie asks on the pay stub, if we have 2 office locations, do we only need to have the headquarters address on the pay stub if this is where they're generated? Or if the employee works out of the other office, does that need to be on that worker's pay stub?
And this is exactly where I worried about that question because we have to know the facts. Who's at that office? Is the person who could solve a pay stub problem or answer a pay stub question at that office? That would go to, like you said, Bruce, the agency's position here, which is they need to know where they can go. Is one of those offices open to employees? Do they have access to it? Do they not? So I wish that it was an easy answer. I know that's everybody's preference, but as with most things, it really is, we need to know the facts here. We need to know what's going on and to decide what is the most defensible position for you, because it is not a question that the law has made clear. So it's a matter of figuring out what puts you in the best position to fight for, hopefully, your answer being correct. And if that's not possible, your answer having been a reasonable one.
Okay. Let's see. Alvin followed up, and the question was yes through, I think you were talking about access, yes through employer or intranet or mobile app self-service access. And I think
okay, so yes, can be done. Just make sure you're doing it right.
Okay, we have, is the business phone number required on the pay stub?
No. That was
Okay,
my
and
answer of the day. Thank you.
Marissa asks kind of an overall question that I think it'd be, let's wait just a couple of minutes because we only have like 2 more slides. Let's go through those and then we'll cover that. So this was related to like Brandon's question earlier. We have an existing PAGA action. Can this help us? Can we use it in some way?
So the to the point answer is not directly, but arguably indirectly. So none of this technically applies to a previously filed PAGA action. And indirectly, it may have and likely will have some collateral benefits. And primarily as it goes to the court's ability to reduce penalties or to exercise his or her discretion in awarding the amount of penalties because they can reduce those penalties. These 2 laws have a very significant legislative history. It goes to the fairness argument. For instance, if you were a weekly payroll company or a pay period company, should you pay more than someone that is bi-monthly or pays every 2 weeks? So those fairness arguments would go into the court's discretion. And arguably, although it's not 100% clear, this new legislation and the legislative history behind it would go, I think, a long way in convincing either a mediator or a trier of fact to use discretion as to fairness as it goes to many of these issues that we just talked about.
Yeah, and the idea is when appellate courts review Superior Court cases, they will often ask, has the legislature spoken? Because an appellate court is often ruling on a case that started 3, 5, 8, 10 years before in Superior Court, and they will ask, has the legislature spoken since this started? Will that inform us? And here, it clearly has. The legislature had not changed PAGA in 20 years. They did a couple of procedural things in the labor agency, but nothing in regards to PAGA and its impact. And we can say when they finally did act, my gosh, they made all these dramatic changes in penalty structure that we're all talking about. And clearly the plaintiff attorney will be a member of the California Employment Lawyers Association, more than likely, and maybe also the Consumer Attorneys of California, which is the overall plaintiff attorney group. And they both signed on to the legislation as we totally support this. So there's a lot of arguments we can make. And of course, courts have been overwhelmed, and we can show how this is intended to minimize court involvement and not clog up the courts. So let's settle this thing for less than we've been talking about. Yeah, it'd been nice if they had been able to do it retroactively, but that, they negotiated hard for everything we got, and we appreciate that.
Yeah, the other thing is all of these negotiations and what would typically be legislative history is sort of behind closed doors. With this private negotiation between labor and management, which will make it even a little bit more difficult to argue. But the statutes say what they are, and you can infer what the thought process was.
And at least, like Bruce said, the public letters of support, the public statements that were made, at least some of those are available. So.
Yeah, because if somebody, we're saying the legislature agreed with this private negotiation that the penalties were way too high. I mean, that's a fair statement to make. So, and then real quick, can we build on the success of PAGA reform? Most of you know, we have at Housing Contractors our U-turn campaign. It was interesting. Democrat legislators would say, in regard to the PAGA reform, this is how government should work. Well, the government didn't work this. This was employers forcing, a private discussion that got this, and the legislature just said, okay. But the legislature should have and could have solved PAGA 10 or 15 years ago. So we want to pursue that. As you know, we have our U-turn campaign supporting moderate and conservative candidates in the general election, and we did it in the primary campaign as well. So when we contact you, we want to keep turning our legislature to a more business-friendly group, and away we go. So Marissa asks, this is a good kind of claim here, view. Can we have an overview of a PAGA claim? As another member mentioned, does the claim say when, who, and how? The answer was that the claims are vague. So how does the process work? The claim will require us to send records to plaintiff attorney, and they will comb the records to find offenses. So Carrie, I know you were talking about this.
Yeah, so a little of all of the above. I'm going to actually start with the end of that question, which was about sending the records to the plaintiff's attorney. So that would be in response to a records request, which I know Kyle talked a lot about, because that can trigger the time period for some of this reasonable compliance and whether it was before or after. So a records request can come from an employee or from their authorized representative, which in a union context is usually going to be their union rep. In any other context is generally going to mean their attorney. And it's a request that says, hey, I want a copy of my personnel and payroll records. If it's coming from an employee, it often looks quite that simple. They call and say, hey, I want a copy of my pay stubs. If it's coming from their representative, it's generally a letter from an attorney, and it's going to give you all of the labor code provisions that allow them to ask for this. They're going to ask for those records. They may well ask for other records that you don't have an obligation to provide. So not only for the timing reasons, but for others, it's important to get those requests to your attorneys as soon as possible. We'll work with you to figure out what do you have to produce, what do you not have to produce. We'll work with you on strategy for how, when, and where those things are produced, for what order they get produced in, everything. The strategy starts that early. So that's a records request, and you generally are obligated to respond by allowing inspection of the records and or copying for certain records within specified timeframes that are generally 21 and 30 days from your receipt of that request. So again, as part of your PAGA response team, who is going to process those requests? Do they know what they look like? Are you going to get them to the attorney on time? Are you going to be able to collect the records in time? How are you going to be able to do
this is him.
in response to a records request? The other aspect of your question dealt with a PAGA notice. So those are the letters that the employee, again, or their attorney sends to the LWDA. The statute says,
Okay, and that would be for CBS.
Those ones have to come to you by certified mail. That is the only way that the statute allows them to be sent. You may get requests from these attorneys asking you to accept them in a different way. Again, talk to somebody before you respond to those kinds of requests. The statute says submit it to the LWDA online, send a copy to the employer by certified mail. These are generally a letter that's going to be on law firm stationery on their letterhead. We may see changes in that. They may try to make them look more discreet now that you have more options to cure. So be prepared for that. As of right now, most of them are sent on law firm letterhead. They'll be, again, directed to the LWDA most of the time. Some of them will say, and the employer. They'll generally refer to the California Private Attorneys General Act. They may refer to PAGA. They may just refer to Labor Code Section 2699. So again, learning these signs, learning what to look for in these letters. By statute, they are required to list all provisions of the labor code that the person is alleging were violated, and the, quote, facts and theories supporting those violations. That's all the statute says. The case law has delved into what those facts and theories might look like. Courts have tried to say we need more. Appellate courts have fought back and said we just need facts and theories. So that's an ongoing debate. And most of the question of what your notice looks like is going to depend on what plaintiff's firm is at the top of that letterhead. Some of them will have done a ton of research. They will know everything about you before they send that letter. There will be lots of details. Some of them will do the exact opposite, and it's a cut and paste job where they plug in your name and the employee's name, and everything else is a lot of very general cure or violations. So it can be anything in between and across the board.
Okay, and then we had a question, is there a resource that could be shared that details all of the current pay stub and wage statement requirements? I'm going to just put where everybody can see it, in the Q&A part, the DLSE, I think I got that in there. There's another question. Suppose the employee's first language is Spanish. Do pay stub cures need to be in the employee's first language?
The pay stubs would generally be in English, and are in fact required to be so that the LWDA can read them. If you were doing some form of a summary report, I guess it's possible there could be some Spanish translation there. But for a pay stub cure, you're generally going to be limited to those documents that would be going to an employee. The cure plan or the notice of cure goes to the LWDA and to the aggrieved employee, so there's no need to translate that. Other potential cures could involve distribution of policies or information, and it may be beneficial to translate those into Spanish. But for pay stubs specifically, I'm not seeing where we would necessarily need Spanish translation. So if there's a specific cure you have in mind, definitely we'd want to talk it out, but it's not something obvious to me, at least right now.
Yeah, and Bruce, on the wage statement requirements, Labor Code 226 and 226.2 basically sets forth those requirements.
So somebody could just Google those.
Pop right up.
Yep. California Labor Code 226 and 226.2. Okay. Wow, we are, I think, out of questions. 11:52. We're 8 minutes short. So we covered a lot of ground. Thanks everyone for attending. Thanks Kyle and Carrie for preparing this and giving us an insight. This is a very exciting time that we have real help. We do need to do some work to get ourselves in place to take full advantage of it, but it's right there in front of us. Let's prove plaintiff attorneys wrong, that we can do the work, we can be prepared, and we can minimize these things. And Mark says, great job, Kyle and Carrie. This was excellent webinar, very comprehensive and thorough. Great job.
Thank
And
you.
Kurt says, thank you all for the efforts and information day. So thank you both.
I just wanted, one thing is we just kind of covered the minimum of these two new statutes, and there's a lot to discuss with your attorney. So I just want to, say that these are the generalities. There's a lot of specifics and a lot of strategy that's going to go into, being proactive, whether you cure, et cetera, and resolution strategies. So I just want to make that point.
Well, I think what both of you said that I think is important for us to know. You, as defense attorneys, need to know a whole lot of stuff. Our job is to give you the facts, the unvarnished. Don't hide it. Don't avoid it. Tell you the realities. And you're going to analyze all those pieces and parts and come back. And as you said, Carrie, you can give us options now. You can say, do you want to do this? Do you want to do that? What's better for you? And we can analyze what's the most cost-effective way for us to dealing with these various parts. So that's why, again, I think we need an attorney who understands this very, very thoroughly to take full advantage, because we can't know all the detail you all are talking about, but we can give you the information so you can tell us how we can benefit the most as we go forward. All right. Well, I think we'll be able to say, here we are, 11:55. Thanks everyone for attending. Hopefully this makes a big turnaround, that again, we can take PAGAs from being a nightmare to a manageable problem if we do the right things here. And that's a very exciting time. So thanks again, Kyle and Carrie. We'll talk to everybody soon.
Thank you all.
Thanks, Bruce.
Have a good week.
Thanks.